Hello and welcome, listeners. Thank you for joining us on today's podcast episode. I am your host, Chris. I work as a legal officer within the Insurance and Pensions Supervision, and today we've got an informative session lined up for you. Today we will be delving into the Companies Act, the cell companies carrying on business of insurance regulations, which are practically known as the PCC regulations, together with Dr. Velatanti and Dr. Zarafa. So before we dive into the specificities, I just wanted to lay down the groundwork. So on the 22nd of December 2022, the MFSA issued a circular on the changes that might be on the horizon with respect to the PCCs. And in this episode, the aim of this episode is basically to break down these proposed amendments and explore what they mean for the financial landscape. Today we will be discussing the proposed changes highlighted in the consultation document on the amendments to the PCC regulations that have been published. In this respect, may we take the opportunity to remind our listeners that they are only proposed amendments, which are not binding and are subject to changes and revisions. As a result, we encourage you to submit your feedback, which will be reviewed from our end and for which a feedback statement will be published in due time, following obviously the lapse of the consultation period. May I also kindly remind you that a new procedure for consultations has been put in place, wherein amendments to the PCC regulations per se are uploaded on the government portal, and therefore feedback to the said regulations will need to be provided through the said portal. Whilst the consultation with respect to the amendments to the new Chapter 17 to the insurance rules and amendments to Chapter 5 of the insurance rules are published on the MFSA website, and that feedback will need to be provided through the MFSA portal. As you might already be aware, both consultations refer to each other. However, we would like to clarify that separate feedback would need to be provided depending on the legal instrument you are providing feedback on. So, with respect to the publication of the consultation document, it was noted that MFSA has liaised with the Malta Business Registry to conduct the necessary amendments to the PCC regulations, since these regulations are issued under the Companies Act, which falls within the remit of the MBR. As a result, the consultation document has been issued jointly between the two regulatory authorities, and two separate consultations have been issued, one on the government portal and one on the MFSA website, as mentioned before. With respect to the consultation on the government portal, it's important to note that this contains the following documentation. You have the PCC regulations, including amendments in red for ease of reference, and also the amendments to document to the same regulations. Then you have the consultation document that has been issued on the MFSA website, which contains the following documentation. A new Chapter 17 to the insurance rules, entitled Cell Companies Carrying on Business of Insurance, and also an amended version of Chapter 5 of the insurance rules. Now, delving into the amendments to the PCC regulations, I'm going to start with you, Demi. So, with respect to the PCC regulations, can you kindly provide us with an overview of the proposed amendments, please?
Thank you, Chris, first and foremost, for providing us with an overview on the amendments to the PCC regulations. Yes, as you rightly mentioned, the MFSA is proposing to conduct a number of amendments to the PCC regulations. In line with the circular published on the 22nd of December 2022, the MFSA is proposing to remove the non-recourse clause referred to in Regulation 15 of the PCC regulations. By utilizing the non-recourse clause, only the cellular assets of that cell may be utilized to satisfy the cellular liability of such cell. The new proposal to remove the non-recourse will require each and every cell of a cell company to maintain recourse to the core. This proposal is not something that is being taken lightly. We understand that there is concern from the industry to remove the non-recourse clause, and in this respect, we are proposing to include a transitional period of 10 years from the date of the coming into force of this regulation. By means of this transitional clause, cells which exclusively carry on business of affiliated insurance or business of reinsurance, and which have entered into a specific written agreement which provides that only the cellular assets of that cell may be utilized to satisfy the cellular liability of such cell, in line with the PCC regulations, may continue to pursue the business as approved by the competent authority for a period of 10 years. This introduction is being proposed to ensure and encourage as much as possible the smooth transition of these amendments without jeopardizing the thriving market for the PCCs in the jurisdiction of Malta.
Thank you, Demi, for providing that overview of the amendments to the non-recourse clause. Moving on to you, Andrea. So, are there any amendments which will be carried out to the PCC regulations?
Yes, Chris. In fact, the MFSA is also proposing to conduct amendments in Regulations 16 and 17 of the PCC regulations. The MFSA is proposing to amend Regulation 16 on the transfer of the cellular assets from the cell company. The proposed amendments to these regulations will differentiate between the transfers of the cellular assets and liabilities attributable to any cell of a cell company that may occur in the case of a transfer of the said cell to either another cell company authorized under the Insurance Business Act, or else to an authorized insurance undertaking or a European undertaking, reinsurance undertaking, or a third country insurance undertaking. In this respect, a different procedure on how to conduct the transfer will be adopted for each instance. Furthermore, we are also proposing to introduce a provision to give the MFSA as the competent authority the power to issue rules. The new chapter will include the detail on the manner in which a transfer of the cellular assets is to be done. In line with this, the current procedure that is included in the regulations will be removed and included and amplified further in the proposed new Chapter 17 to the insurance rules.
Thank you very much for that, Andrea. So, Demi, apart from what Andrea just mentioned, can you clarify whether there were any additional introductions to the PCC regulations, please?
Sure. In addition to what has been said, the MFSA is also proposing to introduce new regulations 16 sub-article 10, 16 sub-article 11, and 16 sub-article 12, and a new Schedule 1 to the regulations. The new sub-regulation 1610 will clarify that Article 83 of the Companies Act on the reduction of share capital will not apply. However, immediately after having sought the competent authority's approval to transfer the cell of a cell company to another cell company authorized under Article 7 of the Insurance Business Act, but before the cell transfer approval is granted, the cell company which will be transferring the cell shall deliver a notice to the registrar for registration to inform them of the said transfer. A draft of the said notice can be found attached to the said regulations. The new sub-regulation 1611 and 1612 of the said regulations will require that the cell company transferring the cellular assets to provide the registrar with a copy of the cell transfer approval once it is issued by the competent authority for the registry to proceed to strike off the name of the cell from under the name of the cell company upon the completion of the said transfer and inform the MFSA of such. The MFSA is also proposing to amend Regulation 17 of the PCC regulations to extend this regulation not just to the liquidation process of the cells, but to the full process prior to conducting a liquidation of cells, including the seizing, the runoff or servicing and winding up of the cells. This methodology will also be included in the proposed in Chapter 17 to the insurance rules. A new Regulation 17 sub-article 3 is also being proposed together with a new Schedule 2 to the PCC regulations to include that where the cell company informs the competent authority of its intention to cease to carry on business, the said cell company shall deliver to the registrar for registration a notice in accordance with the proposed in Schedule 2 to the regulations. The notification is to be submitted to the registrar by the cell company, and it will include a declaration by the cell company of its solvency or insolvency as applicable, and that one of its cell shall be wound up.
Thank you very much for providing us with that overview, Demi. Now, both of you mentioned Chapter 17 to the insurance rules. I'm going to turn to you, Andrea. Andrea, can you kindly clarify what the new Chapter 17 to the insurance rules will contain, please?
Yes, sure. As Demi pointed out earlier, we're proposing to introduce a new Chapter 17 to the insurance rules. This will include a structured and a detailed procedure as to how a transfer would be required to be conducted in each different instance that I have mentioned further above, as well as the manner in which a cell would cease to carry out its business and how it is wound up if it is a solvent cell or if it is an insolvent cell, as well as the manner in which a cell company is wound up. However, we did not want to reinvent the wheel. The intention of the MFSA is to remove the reference to the current procedure related to the liquidation of a cell company in the PCC regulations, and to include an in-depth procedure of this in the proposed new Chapter 17. The intention here is to structure the new chapter to include the different scenarios under which the cellular assets attributable to every cell of a cell company may be transferred to, and then go into the detail of how such transfers in these different instances may be conducted. So, for example, with respect to conducting a cell transfer from a cell of a cell company to another cell company, which is authorized under Article 7 of the Insurance Business Act, we're proposing that a set of requirements will need to be satisfied prior to commencing with a portfolio transfer. This is only required with respect to transfers from a cell of a cell company to another cell company authorized under the Insurance Business Act. In such case, the cell company is required to submit a declaration signed by the directors of the transferring cell company to inform the MFSA whether there are any regulatory concerns or any pending litigation. Apart from that, the cell company is required to enter into a draft terms of agreement with the receiving cell company, which shall indicate a number of requirements. With respect to the transfer from a cell of a cell company to an insurance undertaking or a European insurance undertaking or a third country insurance undertaking, a portfolio transfer in line with the applicable provisions of the Insurance Business Act on portfolio transfers would need to be conducted in line with the requirements of the Insurance Business Act as well as the annex to the BOS decision on the collaboration of the insurance supervision authorities of the member states of the European Economic Area.
Thank you very much for that, Andrea. So now you just provided us with an overview of the methodology of how a transfer of a cell company is being proposed to be undertaken. I'm going to stick with you for now. I'm going to ask another question. So Demi mentioned the new Chapter 17 before, and she said that it will contain provisions on seizing, servicing, or running off of the business of insurance and winding up of a cell. Can you kindly clarify further on this point, please?
Yes, sure. Thank you, Chris. The new chapter will contain a procedure with respect to the seizing of the cell. As I mentioned before, we don't want to reinvent the wheel, so the process will be similar to the current seizing process in the Insurance Business Act. In such a case, a new subregulation 17.3 has also been included in the PCC regulations, which will require the cell company to deliver a notice to the registrar in line with Schedule 2 to inform the registrar that one of its cells shall cease and will be winding up. Chapter 17 also includes the procedure which a cell of a cell company is required to follow when it is servicing or running off the business of insurance. The new chapter will also contain a procedure as to how a cell of a cell company will wind up. The chapter differentiates between the winding up of a solvent cell as well as the winding up of an insolvent cell. Finally, the chapter only clarifies the methodology of how a cell company will be wound up, whether such cell company contains cells or otherwise. So what the chapter does in this case is that it requires a cell company which already have cells to first ensure that it disposes of all of its cells before proceeding to seize and then wind up in terms of the Insurance Business Act regulations and insurance rules issued thereunder.
Thank you very much. So like that, we have a very detailed overview of Chapter 17. Now I'm going to move to you, Demi. Earlier on in this podcast, you mentioned Chapter 5 of the insurance rules. Can you please provide us with an overview of the proposed amendments?
Yes, indeed, Chris. So in this respect, the MFSA is proposing to introduce a new provision 5.5.95 on the risk mitigation techniques to be adopted by authorized insurance undertakings. This new provision will provide that the undertakings shall not take into account risk mitigation clauses and/or techniques in relation to the obligation to pay a claim where a reinsurance undertaking defaults, which disproportionately reduces the counterparty default risk on the exposure of a reinsurance undertaking, for the purposes of calculating the solvency capital requirement. This amendment is being undertaken in conjunction with the proposed amendment to remove the non-recourse clause to ensure that other risk mitigation techniques are not adopted in relation to the obligation to pay a claim. A valid claim will need to be honored by the undertaking irrespective of whether the reinsurer is in default.
Thank you for that, Demi. So we are coming to a conclusion on this topic, but before we conclude, Andrea, you have my final question. I would like to ask you to delve into further detail on the transitional period that the MFSA is proposing to introduce with respect to the PCC regulations.
Yes, sure, Chris. As explained above, the MFSA is proposing to remove the non-recourse clause from Regulation 15 of the PCC regulations. As a result, it is proposing to introduce a transitional period of 10 years from the day of the coming into force of the amendment regulations. This transitional period will be with respect to the removal of the non-recourse clause only and will only only be applicable to those cells which exclusively carry on business of affiliated insurance or business of reinsurance, and which have entered into a specific written agreement which provides that only the cellular assets of that cell may be utilized to satisfy the cellular liability of that cell, in line with the current PCC regulations, as well as before the entry into force of these regulations.
Perfect. Thank you very much. So thank you to the both of you for providing our listeners with an overview of the proposed amendments to the PCC regulations. On this note, I would like to take this opportunity to remind our listeners of a couple of points. So first of all, your feedback is welcome and encouraged, as it will allow the MFSA to have a clear picture of any concerns and comments that the market may have. A feedback statement will be issued to the industry following the lapse of the consultation period and following the review of the feedback received. And feedback can be provided on the PCC regulations through the government portal, whilst feedback on the proposed Chapter 17 of the insurance rules and the amendments to Chapter 5 of the insurance rules are to be provided on the MFSA website. We have now reached the end of this podcast. We would like to thank you for tuning in and encourage you to reach out should you have any queries. Thank you.